All right. Good morning, everyone. Welcome to this public session of the Knight Commission on Intercollegiate Athletics. First, I want to thank the John S. and James L. Knight Foundation on behalf of the entire commission for their support of this meeting and our efforts to advance college athlete education, health, safety, and success. The support of this meeting helps us fulfill one of our roles in providing public transparency to the most pressing problems facing college sports. This session is titled Impact of the Proposed House versus NCAA Settlement and College Athlete Employment Cases, including a discussion of Title IX. Before we begin, let's go over a few housekeeping points. First, this session is being recorded, and the recorded video and other meeting materials will be available on knightcommission.org. Second, commission members and panelists, please use your microphones when speaking so that the virtual audience can hear you. And media and public attendees are reminded that we will hold a press conference at 12:30 Eastern Time in the Farragut Square room here in this hotel. And for those who would like to participate virtually, you can use the QR code on the screen to register. Now to the session. The NCAA is in the midst of the most transformational period in its history, pushed by a series of lawsuits challenging the longstanding amateurism model of college sports. If approved, the proposed settlement in House versus NCAA will distribute billions of dollars to current and former college athletes and create a new system for college athlete compensation going forward. At the same time, the National Labor Relations Board and federal courts are in the process of determining whether college athletes are employees and entitled to unionize, receive minimum wage, and obtain other benefits. In today's session,
recording in progress,
particular session, legal experts will provide an analysis of the proposed House settlement and the college athlete employment cases to help you better understand the key points and implications of these cases, including a discussion of Title IX to potential new revenue sharing and benefits. Now, in the interest of time, I'm not going to provide extensive bios for our outstanding experts, and you can find those biographies on our meeting page at Knight Commission, on the Knight Commission website. However, I will introduce our panelists in the order you will hear from them. First, we have Gabe Feldman, Director at Tulane University's Sports Law Program and a Knight Commission legal consultant. We have Janet Judge, partner at Education and Sports Law Group, and Jill Bodensteiner, Vice President and Director of Athletics at St. Joseph's University. Now, following our panelists' remarks, we'll hear a reaction from our fellow commissioner member, Wayne Frederick, President Emeritus of Howard University, and then we'll open the floor to questions from commission members. So, Gabe, please get us started.
Thank you, Len. And thank you all for being here in person and online. I appreciate the opportunity to make these remarks. And I want to be clear on a couple of things. One is my role today is to provide an overall explanation and summary of the legal issues. And then you'll hear some analysis from both Janet and Jill. And it's a pleasure to share a stage with both of you. And that this is current as of 8:32 a.m. Eastern. And what I want to do is talk through first the employment issues and then the proposed House settlement. And then I'll turn it over to Janet and Jill. In the employment context, there are two potential paths to employee status for college athletes that are occurring simultaneously. They are under the Fair Labor Standards Act, or the FLSA, and the National Labor Relations Act, or the NLRA. For the FLSA, the case that is pending is involving an FCS football player and a number of Olympic sport athletes who argued in Pennsylvania that they should be considered employees under the FLSA and therefore be entitled to minimum wage. If that's a minimum wage case, the NCAA moved to dismiss that, arguing that decades of precedent have shown that college athletes are not employees. And instead, the relationship between college athletes and schools is defined by the historic tradition of amateurism and the economic reality of the relationship between the schools and the athletes is that the athletes are primarily students and they are primarily there to receive an education. The district court denied that motion to dismiss, and after a lengthy period of time, the Third Circuit earlier this year affirmed the denial of that motion to dismiss. And what that means, and I'll talk a little bit more detail about the Third Circuit's reasoning, but what that means is that it is possible that college athletes could be determined to be employees under the FLSA because it was at an early motion to dismiss stage. All the judge said was it is not his conclusion as a matter of law that college athletes cannot be employees. So the Third Circuit said, we agree that it's possible college athletes can be employees. We need a further record to determine whether they are employees or not, and said a couple of things that were noteworthy. One is that the relationship between college athletes and their universities is unique, that it is not possible or appropriate to rely on tests for employment status that have been used in other areas, including interns. And two, that this historic notion of amateurism is now frayed because of the ruling by the Supreme Court in Alston, because of other decisions, and it does not provide a justification as a matter of law for concluding that college athletes are not employees. So it was an affirmance of the district court, but there was also some clarification and part reversal sent it back to the district court to apply essentially a new test that applies to college athletes to determine whether they are employees. And again, it looks at what is the economic reality, and it creates a 4-factor test. And it asks if the college athlete performs services primarily for the benefit of the school, under the control of the school, and in return for compensation. So a 4-factor test. And both the majority and the concurrence suggested that there may be a different result for revenue generating sports and our Olympic sports, that those factors might come out differently depending on the athlete, the school, the sport. Okay? So that has been decided by the Third Circuit, sent back to the district court to then proceed with discovery and potentially eventually go to a trial for a final determination. And any determination could then be appealed back to the Third Circuit and potentially to the Supreme Court. The other area of labor and employment law is the NLRA. That's the area of law that says if the individuals are employees, they have a right to unionize and to enter into collective bargaining relationships with their employer to negotiate their wages, hours, and other terms and conditions of employment. And the Dartmouth men's basketball team brought a claim saying that they wanted to be recognized as employees so that they could unionize and collectively bargain over their terms and conditions of employment. The regional director of the NLRB in Boston said that they were in fact employees because the school exercised control over them because they received benefits in return for their work, even though they do not receive athletic scholarships. The team then voted to unionize. Dartmouth has since appealed the finding of the regional director that will go now to the full board to determine whether college athletes, or excuse me, Dartmouth men's basketball players are employees. And they have also refused to recognize the union and have refused to negotiate with the Dartmouth men's basketball union represented by the SEIU. And so Dartmouth men's basketball team has filed an unfair labor practice charge challenging that. So there's 2 issues going on there with Dartmouth. There's another case involving USC. The reason the USC case is important, just to touch on it briefly, is the NLRA, by its language, only applies to private institutions, but only apply to private employers, private schools. Most of the FBS schools are public schools. So the NLRA would not apply to them. Instead, individual state law would apply to them. The theory being brought in the USC case is that the employer of these USC athletes is not only the school, but also the conference and the NCAA. And if this joint employer theory is correct, then every athlete at every school, public or private, would in theory have a private employer through their conference or the NCAA. So the NLRA would apply to all schools, not just private schools. Now there's some nuance there in terms of religious schools, and there might be some exceptions, service academies, but in general. Right? So both of those employment areas are pending right now. And the reason I start with that, and now I'll transition over to the House settlement, is because the House settlement has been talked about as a possible global solution for college sports. The House settlement is an antitrust case. And it's actually three antitrust cases: the House case, the Hubbard case, and the Carter case combined into one. It cannot and does not, regardless of the terms of the settlement, impact the determination of employee status of college athletes under the FLSA or the NLRA. That will be determined in federal court by the NLRB, eventually maybe by the Supreme Court. It also cannot, and Janet will talk more about this, it cannot make any determination about what is permitted or not permitted under Title IX. It can only resolve the antitrust issues that are in front of the court. So that pending House settlement, 2 weeks ago, I'd planned to talk a lot about how the House settlement would be operationalized and the timing. Now we have to talk about whether that House settlement will actually be approved. But let me talk about just the basics of the House settlement and then what happened at the hearing, and then I'll turn it over to Janet. There are three plus primary aspects of the proposed House settlement. First is the back pay, the damages for the antitrust violations that were alleged by the plaintiffs, for the failure of the agreement of the schools not to compensate the athletes for the use of their name, image, and likeness in broadcasts and video games and other opportunities. The proposed settlement would pay about $2.78 billion to athletes in the classes over a period of 10 years. And the settlement would say about 42% of that would come from the NCAA, or the agreement is that 42% would come from the NCAA, and 58% or so would come from reduced distributions from the NCAA to the conferences. And there is a formula for allocating that back pay, those damages, to the athletes, to the ones who are in the classes. And that formula roughly says that 85%, 90% of the damages will be paid to the former FBS football players and Division I men's basketball players. And then the remaining 10 to 15% will be for women's Division I basketball players and then Olympic athletes. And so that's the formula that is agreed to for the back pay. The second part of it is the going forward, how the model for college sports, the compensation model, will change. And the big change is that the schools have agreed that the autonomy conferences, and for the purposes of this discussion, there are 5 autonomy conferences because the Pac-12 was one of the conferences that is named as a defendant in-house. Those schools are permitted to provide up to 22% of a defined set of revenue, and that's defined as an average across the power schools plus Notre Dame, but they can provide 22% of that to the athletes. They are permitted to do that. They're not required to do that. They're permitted to do that. There is, unlike with the back pay, there is no formula to determine how that money gets paid out to athletes. And there's a lot of discussion on a campus level and a conference level of how that money will be paid. And that you don't need a Title IX expert, even though we have one here, to notice that that may raise some gender equity issues. Okay? So Janet will talk a lot more about that. In addition to that revenue share, the 22% revenue share, that pool of funds that will be available to schools that decide to provide the revenue, there are changes made to name, image, and likeness. And if the settlement is approved, schools will be able to pay athletes directly for the use of their name, image, and likeness. But those payments from the schools directly to the athletes will count towards that 22% cap. Right? And that 22% cap will equate to about $20 million in year one, going up to maybe all the way up to $36 million. But if you think about that as a salary cap, and you think about schools then trying to pay athletes directly for their NIL, maybe in promoting the school, they can do that, but that money counts towards the cap. Athletes are also able to receive compensation for their NIL from third parties. That compensation is not counted towards the cap. So you can think about it much like a pro sports model, where there is a salary cap, but the athletes are still able to do endorsement deals. There they call it endorsement deals. Here we call it NIL deals. And that money doesn't count towards the cap unless it is designed to circumvent the cap, unless it is designed as a way to pay the athletes as a salary, but call it an endorsement deal. So what the new structure would set up, the new settlement, is really carrying over from the rules that are currently in place that just haven't really been enforced much over the last few years, is that these deals will only be allowed if they are legitimate NIL deals. And there will be closer scrutiny of boosters and collectives to ensure that these are legitimate deals, which means it actually has to be for the use of someone's name, image, and likeness. It has to be to promote a legitimate business, and it has to be commensurate with some measure of fair market value. And one of the changes that the settlement would bring is there'll be a new enforcement structure to monitor that, to oversee that, and to potentially hand down whatever discipline may be appropriate, and then an arbitration process for the athletes. So that third-party money will not count towards the cap. The money from the school will count towards the cap. There's also, sort of just not to get too far in the weeds and take too much more time, but some of the Alston money, up to $2.5 million in Alston awards, will count towards the cap. And then the last piece of this is the change to roster limits and scholarship limits. So under the terms, again, if the settlement is approved, the scholarship limits that are currently in place will be eliminated for all sports. And the difference between equivalency and headcount sports will be eliminated. And instead, there will be new roster limits. But the schools can pay scholarships to everyone who is on the roster. So football, for example, currently allows 85 scholarships. The new rule would allow them to have 105 roster spots and allow the schools to pay 105 scholarships to those football players. So it will allow additional scholarships. Now, there's rules in place in terms of preventing anyone from losing a scholarship because of this. But the general idea is that this new model allows the power conferences, who are named defendants, to offer up to 22% of revenue sharing, offer additional scholarships, but then be subject to these roster limits. The schools that are not part of the conferences that are named, so the group of 5 schools, they can decide to opt into these rules. They can decide either we do want a revenue share or we do want to offer additional scholarships. But if they do either of those, they are also subject to those roster limits. If those schools decide to do neither, if they say we're not going to give any new benefits to athletes, which they don't have to do because they are not named defendants, or their conferences are not named defendants. So if they provide no revenue sharing and no additional scholarships, they can maintain the existing roster limits. Okay, so it sets up a possible different scenario depending whether schools, quote unquote, opt in or decide not to opt in to the settlement. And the Judge Wilkin had an issue with the NIL model that was set up, concerned that this might take money away from athletes who've been receiving large NIL sums over the last few years, and so asked the NCAA and the plaintiffs to go back to the drawing board, gave them 3 weeks, which I think would expire in about 8 days, to come up with a new model or tweak the language. And then she will look to approve it again. So it may just be a slight delay in terms of approval, but then everything would still be on track for this new model. Or Judge Wilkin might say, this is unacceptable, I'm not going to approve this, and the parties would proceed to trial. That's not a final determination. They can still reach a settlement later on. But we are at a crossroads I think a lot of people didn't expect us to be at, where Judge Wilkin's approval of the preliminary approval of the settlement is not a foregone conclusion. And even if it is approved, there's still an opt-out opportunity for athletes. And if there are a certain number of opt-outs, then the settlement says there will be no settlement. So there are still a lot of variables. There are a number of other antitrust suits that are also pending that have been recently filed, but in the interest of time and getting to the analysis, I will turn it over to Janet.
Thanks, Gabe. And thank you to the commission members for inviting me here today. The last time I was here, I was sitting next to Christine Grant talking about the future of college sports and the arms race around facilities. So it was some time ago. It's a pleasure to be back again. Just some preliminaries. I'm not acting as any of your attorneys, attorney for any of you here today. I'm not actually providing you with legal advice. I'm not speaking on behalf of any of my clients. These remarks are for discussion only. Title IX is quite the hot topic, so I'm going to give it my best shot. As you know, the House settlement is designed to address claims athletics conferences face under antitrust law, which is just one subset of the federal and state laws that govern, or at least are intended to govern, intercollegiate athletics programs today. In order to resolve those antitrust claims only, and in consideration of a promise not to bring certain additional antitrust claims covering the same matters for a certain period of time, the parties have agreed in part to a $2.8 billion past damages payment to be allocated by plaintiffs' attorneys to their clients, and prospective permissive fund payments to be allocated by covered NCAA Division I institutions to their athletes, subject to an agreed upon spending cap. And Gabe did a great job of outlining that. The settlement also has provisions related to athletic scholarships, roster size, and third-party donor NIL payments. I will do my best in the time allotted to address each of these issues. So let's start with the past damage award allocations and why I think they are not an appropriate measure of future Title IX compliance standards. Past damages allocation decisions are being made by the plaintiff's attorneys according to their valuation of the individual antitrust claims of their clients under the cases at bar, none of which include Title IX claims. Accordingly, Title IX does not govern how the past damages claims will be dispersed, and as a result, it's reported that approximately 85% to 90% of those dollars will be allocated to male athletes. For these reasons, plaintiffs' attorneys' decisions regarding past damages allocations are not being reviewed by Judge Wilkin with an eye toward Title IX compliance and are not receiving any sort of Title IX approval by the court. As such, the past damages allocation framework should not be relied upon as setting the standard for satisfying a school's Title IX obligations moving forward when considering prospective fund payment allocations. In short, attorneys Kessler and Berman stated in court that they are not required to consider Title IX when allocating past damages, and they have not done so. Further, as confirmed by the attorneys in the room at the preliminary approval hearing on September 5th, the proposed House settlement does not incorporate, settle, waive, or in any other way compromise any party's right to seek enforcement against the NCAA, the conferences, or any member school for alleged violations of any other federal or state laws, including but not limited to the National Labor Relations Act, the Fair Labor Standards Act, Title VII, the Equal Pay Act, Title IX, and/or their state law equivalents. In fact, both at the hearing and in the press, attorneys for both sides have stated that individual institutions are responsible for determining how to implement the House benefits in compliance with Title IX and other non-antitrust laws. So what does Title IX mean? Title IX is a federal civil rights spending clause statute, making gender equity an affirmative obligation upon acceptance of federal education dollars. As you well know, it provides that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Intercollegiate athletics programs are education programs and activities subject to Title IX. The Title IX regulations specify how the law applies. In the athletics area, Congress expressly delegated authority to the appropriate federal agency to develop a framework for the athletics area. The resultant regulations contain both objective and subjective standards to assess three distinct buckets of athletics gender equity compliance: participation opportunities, athletics-related financial aid, financial assistance, and treatment, including the support and benefits provided to existing teams. In this way, all three compliance areas are at play where the proposed House settlement sets roster limits, impacting participation, and allows payments to be funded using institutional dollars, notwithstanding their source, to benefit athletes and their families who participate in the school's athletics program only. And in this way, it's athletics-related financial assistance and treatment. The scope of Title IX's coverage in this regard appears consistent with the opinion issued by the Title IX expert for the defendants in the House litigation that applied to broadcast NIL payments. In addition, it effectively mirrors statements in July attributed by ESPN to Catherine Lehman, the Assistant Secretary for the Department of Education's Office for Civil Rights, the administrative agency charged with the enforcement of Title IX. In her remarks, Secretary Lehman is reported to have said, schools must provide equal athletic opportunities based on sex, including with respect to benefits, opportunities, publicity, and recruitment, and must not discriminate in the provision of financial aid. In the new NIL environment, these same principles apply. In 2022, U.S. Secretary of Education Miguel Cardona told ESPN, when reflecting on third-party NIL payments generally, quote, "Some of the concerns I have is that it's going to be the male athletes getting paid and the just as committed, just as hardworking women athletes not. Universities must adapt and create structures that are monitoring this, that are communicating what they're doing to proactively create equity." It's also important to note some counter arguments to the Title IX coverage. Some have argued that fund payments are not education-related payments and thereby are not covered under Title IX. As noted earlier, Title IX expressly includes opportunities and benefits associated with athletics participation. Fund payments clearly are both athletics opportunities and benefits of participation, and I would say just as education-related as barbershop chairs, gaming systems, DJs, and sleeping pods in locker rooms, and those are all covered under Title IX. There are arguments that Title IX should not apply to revenue payments made directly to athletes and that employment laws are better comparators. I agree that different standards apply in the employment context for sure, but we are not there yet. These payments are related to athletics participation, and until athletics participation is deemed to be employment, I believe that it's more likely than not that the Title IX athletics framework applies. This is consistent with case law distinguishing Title VII from Title IX. I also understand there are arguments that failure to provide the vast majority of fund dollars to men that participate on revenue sports teams will create legal risks for schools. I think unless schools collude to depress the market and thereby will face additional antitrust challenges, I believe that schools are permitted to allocate institutional funds consistent with Title IX. In short, I believe the question is not whether Title IX applies, but rather how Title IX will apply. While official guidance and judicial direction regarding the how is not yet available, and with the caveat that there's no telling what any individual judge will do on any given day, I've outlined ways I believe Title IX would apply in light of the current jurisprudence, and other ways it might apply if the House settlement is approved in its current format, and depending on how schools may choose to distribute up to $22 million of institutional dollars to their male and female athletes. Let's start with roster limits. As Gabe noted, the proposed House settlement sets roster limits for men's and women's sports. Schools may populate their programs with squad sizes that are equal to or fall below the sport-specific roster numbers. To be clear, these roster caps do not exempt schools from otherwise meeting their Title IX participation compliance obligations. Schools will still have to comply with one of the law's 3 participation tests, and these roster limits likely will have immediate impact for schools under each of the 3 tests. Next, I'll talk about athletic scholarships. The proposed House settlement also eliminates existing NCAA scholarship limitations for men's and women's sports. Instead, covered NCAA Division I schools will be permitted to offer as many or as few full or partial scholarships as they please to athletes on their teams, and Title IX will continue to require that athletic scholarships be awarded in proportion to the number of men and women participating in a school's athletics program. Current agency guidance allows for 1% or less disparity between the percentages of athletes and scholarships awarded by gender, absent a narrow, very narrow set of non-discriminatory defenses, none of which include revenue or revenue generation. In other words, if 45% of the program's athletes are male, Title IX expects between 44 to 46% of all scholarship dollars awarded would go to male athletes, along with a similarly aligned distribution to women participating in the program. Note the comparative baseline is not the undergraduate enrollment numbers, as have been widely reported, but rather the unduplicated count of men and women who participate in a school's athletics program. For purposes of athletics-related financial assistance, multi-sport athletes are counted one time only. So what about the future allocation of fund payments? Well, above and beyond athletic scholarships, the settlement provides broad latitude to schools to decide if and how they will use institutional funds to provide additional dollars to athletes and/or benefits to athletes and their families. Per the terms of the proposed settlement, schools will only be required to keep payments within an agreed-upon cap and will not be required to prove fair market value in the first instance, including for payments that may be characterized as NIL, institutional brand promotion, or any other type of distribution and or payments for personal benefits, including but not limited to vehicles, travel expenses, and the like, provided to student athletes or their family over and above the payments and personal benefits currently permitted by the NCAA rules. Even so, schools that seek to defend their payments against legal challenges external to the House Settlement Agreement, including in the Title IX space, will need to be able to show their work. So what about direct revenue, market payments, or distributions as financial assistance? News reports state that some schools are considering allocating payments based on rev share or market rate distributions. In other words, schools will distribute dollars to athletes without requiring anything in return other than their athletics participation. As a preliminary matter, it's important to address how sport revenue is treated currently under Title IX. In short, revenue sports and the revenue they may generate are not exempt from Title IX coverage, notwithstanding multiple legislative efforts, including those made at the time the law was passed, and attempts thereafter to carve out revenue exceptions. These legislative attempts and their failures are well documented and are referenced in the preamble to the 2024 Title IX regulations. Similarly, administrative and judicial bodies have uniformly held that revenue production is not a justification for a school's failure to provide proportionate athletics-related opportunities and benefits to men and women, including in the allocation of athletic scholarships and in the provision of treatment and support directly benefiting men's and women's teams and male and female athletes overall. The law's application to the allocation of revenue, including dollars that may come into a school as a result of media rights agreements, ticket sales, or even private donations, is not a new concept under Title IX. As reported by ESPN, Ms. Lehman also stated, quote, "As has been true all these decades, Title IX requires schools to ensure that when accepting and using private donations, schools do not create disparities in benefits, opportunities, and treatment on the basis of sex that result in the denial of athletics opportunities," end quote. The only new fact here is that the proposed House Settlement Agreement purports to lift current NCAA restrictions on institutions to use their tax-exempt dollars to provide direct compensation to athletes above and beyond the cost of attendance and any available Alston payments, rather than spend the same dollars internally to support existing participation opportunities subject to Title IX. Unless courts create a wholly new application of Title IX that ignores the current rules concerning how allocations of financial aid and financial assistance dollars are evaluated, it is likely that Title IX will continue to be interpreted to require payments characterized as rev share, market rate, or simply fund distributions to be allocated proportionately. Title IX's 1979 policy interpretation states, quote, "When financial assistance is provided in forms other than grants, the distribution of non-grant assistance will also be compared to determine whether equivalent benefits are proportionally available to male and female athletes. A disproportionate amount of work-related aid or loans made available to the members of one sex, for example, could constitute a violation of Title IX." So what about NIL payments characterized as NIL, brand ambassadors, IP licenses? If schools choose to characterize the payments as compensation for NIL, IP licenses, brand ambassadors, etc., based on objective valuations, the question remains whether Title IX requires the total dollars to be apportioned equitably by gender prior to distribution, likely resulting in differing numbers of men and women benefited, or whether the law will be interpreted as requiring that an equitable percentage of men and women be benefited, likely resulting in differing dollar awards in the aggregate based on objective and defensive fair market valuations. In either case, schools would be required to articulate and follow a non-discriminatory policy of distribution. These policies will be the subject of intense scrutiny by all sides and will be especially susceptible to challenge if based on the value of a sport or position on a team rather than valuing the individual athlete in the market. In any event, it's very unlikely that Title IX would permit a policy that seeks to award dollars to athletes based on their market rates without any accounting for gender, and that would likely apportion the lion's share of dollars to a significantly disparate number of men. In addition, plaintiffs' attorneys have already signaled their intent to challenge reliance on what has been characterized as a discriminatory market. And by plaintiffs' attorneys, I'm not restricting that to Kessler and Berman. If purchasing the non-exclusive NIL or IP or brand ambassador rights from athletes without using them or requiring athletes to do anything in exchange for the payments, schools may face claims that their compensation system is simply a pretext for apportioning fund payments to men disparately or rev share. In short, any distribution of these dollars will be examined both around the method of allocation and the resultant impact on the school's athletics program. For example, if a school's allocation of dollars is found to be equitable, but then has a disparate impact on the school's provision of publicity or recruiting support for its programs under the treatment area, Title IX's treatment component is triggered. Under this third area of treatment, schools are required to provide equitable treatment, benefits, and support for their men's and women's athletics programs overall. Depending on how schools structure their fund payments to students, Title IX will apply if the payments result in disparate treatment. The obvious treatment areas are publicity and recruitment. It's not surprising that Assistant Secretary Lehman noted these in particular. It may include new treatment categories, for example, the provision of NIL opportunities. As press reports have made clear, many in the industry regularly describe the fund payments, including any NIL dollars, as money needed to recruit and retain talented athletes. Coaches state that they need these dollars as soon as possible to align with the recruiting cycle. In the recruiting context, Title IX requires that men's and women's programs be provided equitable recruiting support, including financial support. To date, OCR at least has assumed that recruiting budgets should be equitable, absent clear and objective non-discriminatory reasons for any disparities. If deemed to be NIL or branding payments, schools' use of an athlete's NIL to promote their programs may also result in disparate allocation of publicity for men's and women's sports. For example, if 75% or more of the dollars run to football players in an effort or designed to promote their program, you can imagine where the publicity disparities may result. And just don't forget about concerns around the market itself. For those who tuned into the House hearing on September 5th, you may have also seen the lawyers and Wilkin discuss what was characterized as an inequitable market based on a history of discrimination against women, included as chronicled in the NCAA's Kaplan report. Well noted, Judge Wilkin moved on quickly after appearing to conclude that for purposes of antitrust law only, the market is what it is. That may not be the case under Title IX, where schools seeking to rely on external market realities may be asked to justify their role in the history of the creation of the market. Finally, I'd like to talk about third-party donor-funded collectives and significant assistance. External to the use of school funds, true market conditions may benefit male athletes disparately, and athletes and schools may benefit from those payments without Title IX concerns, provided the schools do not provide what has been deemed to be significant assistance to these third parties. In providing financial assistance to any of its students, a recipient of federal aid shall not, according to the regulations, through solicitation, listing, approval, provision of facilities, or other services, assist any foundation, trust, agency, organization, or person which provides assistance to any of such recipient students in a manner which discriminates on the basis of sex. The Department of Education's Office for Civil Rights is tracking on this. In her statement to ESPN, Assistant Secretary Lehman said, likewise, Title IX prohibits schools from providing significant assistance to any outside organization that discriminates on the basis of sex. These core Title IX principles operate unchanged today. In conclusion, the question to be asked, if a school intends to use up to $22 million of institution dollars, are they doing so in a proportionate manner under Title IX? If not, what are the non-discriminatory reasons other than market or revenue share or past damages that they are relying on in order to ensure Title IX compliance? And finally, what is the tax document that will be issued as a result? Will it be a W-2 or a 1099? And speaking of W-2s, I'll pass the microphone to Jill.
I've never been a part of a W-2 segue, so thank you. Janet gave some great caveats at the beginning that she's not anyone's lawyer in this room. I'm not even a real lawyer. So don't let the yellow pad fool you. I am a recovered lawyer. I practiced labor and employment law, but I am now inactive in all 3 states, and I have entered the realm of being an athletic director. So I want to thank the Knight Commission not only for having me, but for all the great and important work that you all do. So thank you, and keep up the great work. So there are so many interesting issues related to employment of athletes, and we could talk about in depth about the procedures here, what's going to happen. We could talk about the timeline. We could talk about what might collective bargaining look like. We can talk about potential damages. We can talk about the role of Congress. So there's a lot packed in here. I've decided to use my 10 to 12 minutes to really dig into the Johnson factors that Gabe outlined at the beginning of his remarks. And so a couple background notes about the Johnson versus NCAA factors. And again, that's the Fair Labor Standards Act case. First off, I think it's important, no one's picking on college athletics, right? The NLRA was passed in 1935 and the FLSA in 1938. And almost every industry has gone through this. This is part of the history of interpreting those laws that are intended to protect employees. So we have cases on volunteers, cases on independent contractors, see Lyft and Uber, and that whole situation now, which is very comparable to what's happening with college athletes. We've got cases on trainees, we've got cases on prison laborers, and now we have cases on college athletes. And so this is part of the process when you take 1930 era laws and you try and apply them to current day facts and situations. I'm going to focus on Johnson instead of the Dartmouth case or even General Counsel Abruzzo's comments from the NLRB, because as Gabe teed up, I think the Johnson case is a little more nuanced to college athletes. And so the NLRA used 3 factors, and the Dartmouth case basically services, control, and compensation, and maybe arguably a little bit square peg round hole. But I thought the Third Circuit majority opinion did a nice job of saying college athletes are different, and here's a 4-part test that we should use for them. So with that nuance, I'm going to focus my comments on that case. And finally, I think it's really important to remember that this history of case law, it's not like it's not necessarily a ledger. You can't look at the 4 factors and say, yes, 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 right? It's the totality of the circumstances. That's what sort of this economic realities test means. And so the actual quote from the Third Circuit case is, the touchstone remains whether the cumulative circumstances of the relationship between the athlete and the college reveal an economic reality that is that of an employee and an employer. So we're looking at this holistically. That's sort of the point of the economic realities test. So with that background in mind, I'm going to start with the first factor in the Johnson case, which is, do the athletes perform services for another party? And so, is this work? And if it's not work, what might it be? And this is work, it's fun. Play. It might be play. And so is this work or is this play? And the opinion goes into a little bit of a conversation about the differences between work or play. So when you pass a student on our campus erging, for those of you not familiar with rowing, that is land rowing on an erg machine, and their heart rate's up to 175 and they're working their butts off, how does that differ from my rowers who spend all of the days they're not on the river erging? And so that's the first factor. Is it work or is it play? Are these services? And so, if you're a practitioner, you start to look at what are the factors that differentiate your varsity athletes from your club, your IM, your fitness gurus on your campus. And that's how I see a little bit of factor one. So, and one of the quotes in the opinion was, we need to find those, whether athletes or those athletes whose play is also work. Right. So that's a little bit how I see factor one. Factor two is, are those services that we just talked about necessarily and primarily for that party, the other party, the institution's benefit? And I'm going to raise 2 issues here that I think will come up under this factor. And the first is really important, and that is the educational value of sport play, if it's really work. And in fact, the majority opinion in the Third Circuit Johnson case said, I'm going to distinguish this from a case called GLATT, G-L-A-T-T. And GLATT talked about internships. and, talked about the value in an internship. Is it for the employer? Is it for the student? And they said here that the GLAT factors, with all due respect to the district court who applied them, shouldn't apply here because these athletes aren't even getting academic credit. And so as we think about, I believe this is something the Knight Commission has talked about for years. Should they be? Is this a model, especially for some of us in the Atlantic 10 and others, Division III, and who are truly saying, for most, all of my athletes, this is part of the educational experience. And so I think that's a really important factor that comes up in this, for whose benefit is it, as the majority opinion called out. And the second factor I want to mention under this is, where does revenue come into play in all of this? And this is where the concurring opinion, Judge Porter, also a Pennsylvanian like myself, spent a lot of time talking about the revenue, and does the revenue differences by sport, by institution, does that justify a different analysis under these four factors? And then there are many other things when you talk about for whose benefit is it, that could go on either side if there was a ledger. And I'm not going to steal the thunder of the panel coming after us to dig into those a little more deeply. The third factor is under the part are the services under the party, the employer, alleged employer, institution's control. And so you got a little bit of this in the Dartmouth opinion, which I think was overly broad, by the way, that's my analysis, for better or worse. A little bit of this, well, there are rules. Games require rules, right? Well, guess what? So do independent contractors have rules. You can't come on a campus and sexually harass somebody. There's quality control. There are regulations that are part of almost every aspect. And so you can be an independent contractor for a university and still be under some control, because there are rules, there are federal rules, so do the rules of the game, or the fact that you have to show up to a practice, mean that you're an employee? I don't think it's that simple. I think it's a little bit more nuanced. And I think the independent contractor cases on control, while certainly not binding on this discussion, are interesting. Under this control, should it matter? Would it matter to any of you if I told you my best cross-country runner didn't practice with the team once because she was a student teacher? She ran on her own. I think she probably worked out with them on weekends, but in 2020, 2019, she was our top finisher in the A10 without practicing with her teammates. Should that matter under control? Do you think it's of interest that my coaches all give mental health days to their student athletes? I used to have those from my mom, where I could wake up one morning and she's like, I don't even want you lying to me and making up a flu symptoms. Just say I need a mental health day. Our coaches give those. Does that matter when it comes to control? So I think those are really, really interesting factors. But I would encourage the practitioners in the group, in watching online, those of you in athletic departments. I'm not suggesting anyone hide evidence, but I would ask, where are you on control in your department? And is it reasonable or unreasonable? Do we really need to tell our athletes what to post or not post on social media? I worked at Notre Dame for 20 years. It rains a lot, right? And so some coaches had rules that said, you can't post about the weather. Okay, that seems a little over the top, right? So do an examination. I gathered every team rule book. We have 21 sports. I said to the coaches, and I was pleased that 12 of the 21 said respect the university and follow the university's rules. That's pretty good. You're treating them like all students, right? You can't haze, you can't engage in sexual misconduct, but we're not going to tell you when you can and can't drink. We're going to tell you, we're going to tell you what it does to your body. And if you want to be really good at athletics, but do we need 24, 48-hour rules? I think those are all the things that I would encourage practitioners to evaluate. Where are you on control, and do you still need those? The fourth factor is this work, if it's not play, is it in return for express or implied compensation or in-kind benefits? And I think here the concurring opinion states really clearly that this could include even atypical modes of compensation. And so in the Dartmouth case, they looked at financial aid. They looked at the early read process, which is part of the admissions process. They looked at tickets, even though those tickets don't really have a value. You can't sell them. You just ticket stub them for your family to get into the game. But what are the economic realities? And this is again where I think factor 2 bleeds a little bit with 4 when it comes to revenue. And I think it is important to note that Judge Porter of the Third Circuit, in his concurring opinion, really said there may be a difference between those, under both factors 2 and 4, between those sports that are generating significant revenue and those that aren't. And, at St. Joe's, like most Division I AAA schools, we subsidize our athletics to the tune of 80%, right? And that's the average is 77% for D1 AAA schools. That means we spend 20 million, we bring in 4 million. And so should that be a factor compared to football programs bringing in 180 million alone for one program, as opposed to spending 20 million and bringing in 4 million? So I think that revenue weaves in throughout, but I do want to just note that factor 4 is broad. We can't think of just wages there. So, this is where it's going to get very interesting. So as Professor Feldman set up for us, this is now going to go back to the district court, and there's going to be discovery on these factors. So I think the plaintiffs get a chance to amend their complaint, and maybe add different athletes from different schools who show this array. And then we're going to engage in discovery and say, what do the facts show on each of these 4 factors? And I think that's going to be fascinating. Why? And so what could you do? I already mentioned this a little bit, but if you're an athletic director or president, where are you on control? Where are you on benefits? We don't charge for a single sport other than the basketballs. We don't charge. We don't hang signage in the arenas of any sport other than basketball. Does that matter? Do those things matter? So I think a little internal self-evaluation is a healthy thing to do for the practitioners joining us today. Quick note, and then I'll end. Why are the stakes so high? Taxes. If we're spending $21.5 million per school, how is that going to be taxed, right? Because if you're taxing it, you better gross up the thought of what you think you're paying those athletes to cover those taxes. And then let's think about the taxes on the fringes. Think of how many fringe benefits our student athletes get, right? The IRS has guidelines on meals, lodging, equipment and apparel beyond the necessary uniform, flights, trips. I just got back from Croatia, where my women's basketball student athletes toured the country for free. That's a fringe benefit, right? That's taxable to the student athletes, I believe. I'm not even a real lawyer, much less an IRS lawyer. There are visa implications for our international. We have 53 out of our 490 student athletes are international. Their F1 visa status matters. The onboarding and firing, that's a whole different game when you become an employee. Workers' comp. Right now, our athletes get free medical care when it comes to varsity athletic related injuries. They're the first in to get an MRI. Does that all change with work comp? I'm not saying these are bad or good. I'm just saying they are. And then how about the whole notion of financial aid? Does that become a Section 127 of the IRS educational assistant plan? I'm an employee first and foremost, if that's the decision, and I'm also getting a free education. Is that taxable? And then I should have led with this collective bargaining, and we could go on and on and on about the role of collective bargaining. And some of us would, in some ways, there's part of me that says I'd welcome collective bargaining because there's a non-statutory labor exemption to antitrust, right? That's why the pros aren't violating antitrust, because it's collectively bargained, but it's not that easy, right? There's some case law that says religious institutions can opt out and not be covered by the NLRA. Well, that's a whole chunk of us. There's the fact that state schools don't fall under the NLRA the same way as private. So this notion that we can snap our fingers and all collectively bargain as 360 schools, it's not that easy. So those are some of the implications and why this is so important, this employment test. And I'll go ahead and stop there. I was probably too long as it was. I hope that gave you some food for thought, and I'm really anxious for the questions. Thank you.
Actually, thank you all for tremendous amount to think about, and certainly for the richness of information. At this point, Wayne Frederick, President Emeritus of Howard University, is going to give his reaction, maybe representing presidents.
Sure. First, let me thank the panelists for sharing their expertise. Those insights were very enlightening. And although I thought I had my arms around most of the issues, I think now I'm probably going to need a few more arms. The lens through which I see these issues is through 30 years of experience as a surgeon, educated at an academic medical center, so having interns and residents, and having been an intern, resident, and fellow myself. 10 years as president at Howard, trying to manage athletics as well as the entire academic enterprise. And as a parent of two athletes, one a successful collegiate athlete, who now is a pro soccer player, and as a Division I finalist soccer team manager in 1988, which probably is my biggest qualification for giving this response. My first takeaway is the best approach to govern college sports is clearly not through litigation settlements. This is as tortuous and as complex as can be. In my view, getting the structure right is the first step to creating better solutions for all college athletes in this new era. With that point in mind, I'd like to start with what I think would have been a better path for Division I college sports to address key problems, and that is the solution the Knight Commission recommended about 4 years ago. There should be a separate governing entity for the sport of FBS football, separate from the NCAA and funded by the CFP. Some of the revenue and dollars that we're talking about here are very skewed because of college football. I believe a big revenue football super league will exist in 2030 when the next round of media negotiations happens for the major conferences. And as a doctor for more than 30 years, I know that effective treatment looks what it looks like, and I fear that this current solution put forward in the House settlement is a band-aid that is not effective in addressing the core and long-term issues. Instead, as written, the terms will create significant losses and opportunities more broadly, and current problems may actually accelerate. In my view, creating a stable college sports ecosystem begins with separating big revenue football to create more narrowly tailored solutions for that sport. Presidents and boards need much more education about this grand redesign of college sports. I understand that nearly 700 people registered for this event, so clearly there's an appetite for information. However, where we get this information and how boards are going to react to some of this is going to also continue to be problematic. At many universities, enrollment strategies are integrated with institutional support and funding for athletic programs. Presidents and boards of institutions outside of the power conferences will need to consider this point very carefully as they decide how to proceed with sharing athletics revenue with athletes beyond the current scholarship benefits, as you just heard, since such sharing with only one sport triggers the application of roster limits and settlement terms in so many other sports. Additionally, this conversation demonstrates the reality in college sports that one size does not fit all. This House settlement solution is primarily designed, in my opinion, for the Power 4 institutions, their football and basketball programs, and that will share revenue with athletes and operate at a very different level than all other Division I programs. I'm looking forward to our second panel to hear from those leaders on the new model needed for institutions outside of the Power 4. And I'd remind everybody that we spent this summer looking at the Paris Olympics and enjoying so many athletes perform well, primarily because our colleges and universities prepared them for that success. According to the Government Accountability Office, many athletic programs may already not comply with Title IX, as you just heard. And I have significant concerns that without adequate guidance, compliance with Title IX will backslide. And as you heard, one of my children is a young woman who is a freshman at Columbia and looking at their women's volleyball team. And I just want to warn everybody that she's quite an activist, so this could cause us a lot of trouble. In closing, universities, in my opinion, exist for the amplification of other people's humanity. I want to underscore that. The educational environment that we provide makes our collective society a better place. Our athletes are special participants in that. And as a parent of a former college athlete, there's great value in that collegiate experience and the personal development that is gained. My now 20-year-old son, who was drafted at 19, is a joy to engage with as he talks about putting money in his retirement plan, which I wish I could talk about at 20. And as he talks about managing whether or not he should refinance his car loan or get a new car, all of which came from him interacting in a classroom with other people and with faculty members who directed him in the right way. But most importantly, when I watch him sign autographs today for young girls and boys who come to his games, I hear him talk about the fact that he loves being a role model for them. And that, my friends, come from a great academic institution that provided a great education. And at the end of the day, that is what we have to ensure we protect for our athletes. Thank you.
Thank you, Wayne. Before we take questions from the commission members, just want to thank Gabe, Janet, Jill for the richness of your insights and your experiences. And, I think obviously we're all better educated for it. So right now, let's take some of the questions from our commission members. We can start with Jill.
Yes, good morning. And I add my thanks to everyone for the panel presenting to us today. I'm especially thrilled and excited, Janet, to have you here to spotlight the issue of student female athletes in Title IX. And I have this question because notwithstanding being an attorney, this is a lot of information. It's all very complex, and I want to ask for some clarification and make sure that I'm understanding correctly what you have said. I believe you suggested that the proposed framework for the payment of past damages in the settlement, where 75% of the $2.8 billion will be awarded to football players at the Power 5 schools, should not be viewed as court-approved Title IX compliant framework for any individual school's distribution of annual fund payments moving forward. Is that correct? Did I understand that correctly?
Yes, that's absolutely correct. And I think it has provided some talking points that have sort of taken off in the press, but I do think it's incredibly important for people to understand that the past damages allocation is about the antitrust claims before those. Judge Wilkin, she has been skillful in making sure that she does not address any Title IX claims before. This has been in all of the cases that have been before. She has made explicitly clear that it is the institution's obligation to manage their Title IX compliance obligations, and she's not taking a position one way or the other.
Jill, really appreciate your thought-provoking questions that you posed on a variety of factors. And for you, or perhaps for Gabe, for clarification of something that wasn't mentioned, does the House settlement change the minimum number of sports required for D1 membership?
Thanks, Beth. I'll tackle that. And Gabe, buzz me if I'm wrong, or any of my NCAA friends in the room. But just for those of you, a few of the features that differentiate divisions 1, 2, and 3 are the minimum number of sports that an institution sponsors. And so what Beth is referring to is 14 is the minimum for non-football like myself. And I believe it's 16 for football schools. Is that right? To my understanding, nothing in the House proposed settlement impacts those. I'm going to add to that is that we also have minimum financial aid requirements to be in Division 1, right? Division 3 is no athletics aid. Division 2 is some athletics aid, and Division 1 is more athletics aid. And so to be a Division 1 member in the NCAA bylaws, there are also requirements. We've talked a lot about roster limits and financial aid limits by team, but to my knowledge, nothing in the proposed House settlement impacts either the number of sports or the amount of overall aid you need to give to be in Division 1.
Janet, me again, Jill over here. Coming back to you, want to talk about the concept of program elimination and my horrified notion that of the news reports that say that schools might eliminate Olympic sport programs. Being a track and field athlete, former athlete, I would hate that, to enhance the funding revenue of sports, including the payments that will be allowed under the House settlement agreement and overall support, including facility enhancements. So what are you seeing and how are you seeing that?
As a former 3-sport athlete and also track and field, basketball and soccer, I also would be very sad to see elimination of Olympic sports and broad-based sports. Just the mention of the Paris Olympics brings up all kinds of wonderful feelings for me. That said, as a lawyer, There's no prohibition under Title IX from directing schools how to manage their programs, provided the programs remain compliant with Title IX. Many in this room will remember that there were a spate of program eliminations during COVID, where schools were experiencing significant financial challenges, and the courts made clear that financial challenges are not non-discriminatory defenses to failing to maintain a gender equitable athletics program. So if you're going to have an athletics program, Title IX says you have to do it equitably. Program elimination is a quite complicated process, and courts have shown that they are very willing to tell schools, no, you're not, right? They will say, they will put in place injunctions. They will require schools to reinstate programs that they had if schools are not able to demonstrate that they are in compliance with Title IX. And in addition to that, when a school chooses to eliminate an Olympic sport or any other sport, one thing they need to remember is it's not just their participation numbers that are being reviewed. It will be all aspects of Title IX compliance, including participation, financial assistance, and treatment. And so those schools that are best positioned from a gender equity standpoint right now will be in the best position to move forward under the House agreement. And all schools who are not impacted by the House agreement also will be best positioned to move forward in the new landscape of college sports if they are compliant with Title IX.
This is for Gabe. First of all, thank you so much for your commentary, your research, and all the conversation with this move and field goal post, which is college athletics. You just gave us a bunch of information, so I wanted to get a little clarification. I understand that the House settlement terms for athlete revenue sharing are permissive and not required. Can you repeat the information that you reviewed on that?
Sure, and I will offer my perspective. It's rare in this group as a zero sport athlete. But the 22% is permissive, and it is a cap. So it's a maximum. There is no minimum. You can choose not to provide additional revenue. Again, if you're in one of the Power Four conferences, you are bound by the terms of the settlement, regardless of whether you offer additional revenue or not, whether you offer additional scholarships or not. You are bound by those roster limits. If you're not one of the schools in the named conferences, then you get to choose. And if you don't revenue share, if you don't offer additional scholarships, then again, you're not subject to those roster limits. One other thing on the 22% that's been discussed by the parties, and part of where that number comes from, is that 22% does not count scholarships, does not count tutoring, all the other benefits that athletes have been getting. And the idea is that if you add those benefits plus this 22%, then that gets you to about 50% of revenue shared with the athletes. Again, that's the contention made by the plaintiffs and the NCAA as a result of this. And why that is a notable number is because there's a lot of talk about collective bargaining and whether athletes should enter into collective bargaining. In most pro sports leagues, Jock, as you know, athletes get roughly 50% of some defined set of revenue. Now that 22% will increase over time as revenues, assuming revenues do increase, and that 50-50 split, and I think this is important to note, that 50-50 will be for considering all athletes as one group, not sport by sport basis. So the athletes in aggregate would be getting 50% of that defined set of revenue.
So first, I'd like to compliment the three of you on how much useful information you packed into a very short amount of time. And Jill, I would like to ask a question that's really from the viewpoint of a university president. I'm a past university president. This landscape is getting incredibly complicated. We have institutional revenue sharing, perhaps unlimited NIL payments. We have the potential of private equity entering into the picture in a big way. We have the potential for continuing litigation. For a university president, is it actually just simpler to declare all athletes as employees? And so I would just like to get your perspective as someone who's been involved in employment law and now as an athletics administrator.
Thank you for the great question, President Barron. I think that's a very thoughtful question. So should all college athletes be employees? Or, as the NCAA and its members, should all college athletes not be employees, right? And so there are public policy reasons where one could argue whether it's simpler if they're all in one bucket, or, as Chairman Guest and Pierce noted in the Northwestern decision, maybe public policy suggests that in a competitive world, we can't have some employees, some not employees, right? So there is some attraction to say either they're all employees or they're all not employees. I think what that does is doesn't reflect the law. I don't think my rowers are employees. I won't opine on those receiving who are about to receive $5 million a year from their institution. I do not believe most of my student athletes are employees. I don't think they meet the test. I don't think I struggle a little bit with the public policy decision to say, let's make it simple. But I think what you really, great question is, how are we going to do this? If there's a 4-part test in 360 Division I, not to mention Division II and Division III, not to mention club sports, some of which have coaches and are traveling up and down the Eastern Seaboard, how are we going to decide who's an employee and who's not an employee? It seems overwhelming. And the branch that gets no love is the executive branch. We're talking about all these court cases in the judicial. We're talking about all these, should Congress act or should they not? Well, let's look what we do with independent contractors, right? That is equally as difficult, and the stakes are high. If you misclassify an independent contractor who should be an employee, you got a lot of damages, right? So that's where the executive branch pops in, right? The IRS has a form, I think, called the SS8. You complete it and they'll tell you whether you're right that they're an independent contractor. Maybe we have an SS9 and I can fill it out with regard to all of my rowers, all of my golfers, all of my tennis, and the federal government could tell me whether they think they're employees or not. We need some mechanism, because what isn't palatable and tenable is to say, oh, we have a series of court cases, depending on what circuit you're in and depending on your facts, you may or may not be employees, and you run a big risk if you misclassify. That makes us want to run into either they're all or they're not, but I don't think that follows the law. I hope that helps.
Can I just add one quick comment on that too? That's not employee specific, but the idea in labor law, there is an asymmetry when it comes to unionization, that employees have a right to choose to be in a union or not be in a union. Management doesn't get to make that choice. And there are instances we've seen in the history of professional sports where professional athlete unions have decided to no longer be in a union. And the reason they did that is so they could have access to antitrust law, because there was mention of non-statutory labor exemption, which would kick in if there is a union and collective bargaining, but that's a choice the employees get to make. And as many of you probably know, the lawyer who led many of the professional players associations to dissolve their union so they could get access to antitrust law is Jeffrey Kessler, the same lawyer leading the antitrust cases against the NCAA right now. So it's not necessarily as simple as the schools want them to be employees. They can be employees, but that doesn't automatically mean that they are in a union. And if they are employees but not in a union, then you're dealing with both employment law and antitrust issues, which I don't know would be simpler, but it would certainly provide more uniformity, but I don't know if it's simpler uniformity.
I think the conclusion was I made a good decision to retire.
And just one other follow-up to that is, in the college sports context, then you're talking about gender as a BFOQ in employment, right? So to have a whole industry of employment opportunities at an institution that is gender, that is relegated to one gender and no opportunities for the other gender, creates all kinds of additional Title IX and Title VII implications as well.
Thank you for the wealth of information. I am president of Quinnipiac, which is a mid-major university, does well in athletics, and also chair of the MAC, which are very like institutions that have a great deal of interest and success in athletics, but are going to be affected very differently than the Power Five through the settlement. So I'm interested, and probably Gabe, this is for you. just in some rules and then some implications. First of all, to clarify, if an institution changes, obviously we're not the Power Five, so we're not obligated to opt in. We can opt out as mid-majors. If a school provides a change in a scholarship benefit in any one sport, does it then apply to roster? It then has roster limits for all sports? That's a question. And those in the mid-majors, not in the Power Five, who do they have the option not to share financial benefits as long as they don't change any of the deals that they have on scholarships with the students, and therefore are not subject to roster limits? And then I want to just ask generally how you think all of this is going to apply, you collectively, to mid-majors. What's going to happen to them?
So I'll take the first question, and then I'll let Jill and Janet jump in on the second question. Yes, it is correct. And the way the settlement talks about it is if additional benefits are provided, and those additional benefits include either that revenue sharing or scholarships that exceed the current limits. So if you provide one scholarship that was previously not permitted, you are providing a new benefit. And if you're providing a new benefit, then the roster limits attach. But if you do not provide any new benefits, then you can stick with the old roster limits. So it is a binary choice. You're either providing some new benefit, and even if it's just one benefit to one sport, it then kicks in all the other settlement requirements, including the roster limits. And as to mid-majors, I'll defer to Jill if she wants to jump in on that.
Can you repeat your specific mid-major question?
Obviously, this is going to have a different effect on mid-majors than it is on the Power Five. What do you think that's going to be?
I think that there's real questions and maybe even a groundswell towards several mid-majors not opting in. When you look at the roster limits alone, and again, we weren't at the table in negotiating this settlement. And so, to state the obvious, many mid-majors use athletics as an enrollment tool. And so there's 31 athletes who can, when the switch flips on August 1st, 2025, if this is approved, 31 athletes who are currently on my rosters are no longer able to play sports at St. Joe's if we opt in, right? That's a crime. That's a shame. And it's really difficult for a lot of us to swallow, right? A lot of folks who have, non-scholarship football have 130 on their roster, and that will have to go to 105 if they opt in. And so I think that there's some really difficult decisions for mid-majors to make. I suspect several conferences and institutions will say, I don't want to be a part of this. We are content doing what we're doing now for all the reasons. Every institution, we just came from Atlantic 10 meetings. We're in the same league. We have a lot in common. We all have completely different reasons why we sponsor Division I athletics. And so yeah, I think there's a lot of soul searching, and I think it'll impact mid-majors very differently.
And just adding to that, I think there will be enormous pressure, though, on mid-majors to offer 15 scholarships, for example, for men's basketball, which will be an immediate impact that will then bring all of the other provisions of the House settlement along with it. I think when we talk about revenue, everybody here is aware, but just to restate it, we're talking dollars in the door, not net revenue. And when we're talking about the collective budgets of mid-majors as compared to FBS institutions, there is significant difference with some sports programs out there fundraising to meet their operation costs still. And to talk about diverting additional funds to payments to athletes, it would be quite difficult for these schools in particular.
I would one other point to add, and this goes back to Dr. Frederick's point, that antitrust litigation or an antitrust settlement is not designed to create a model for college sports. It's not the role of the law. It's not the role of the lawyers. And if you're a hammer, everything you see is a nail. Jeff Kessler is an antitrust hammer, and his job is to get as much as he can for his clients. and not to be concerned about Title IX and not to be concerned about broad-based opportunities. So if we want a comprehensive solution that takes those things into account, and we'll get into this in the next panel, we can't rely on the product of a settlement, whether it's approved or not. It's not going to provide us with the answers that we want to run college sports and take into account mid-majors, majors, women's sports, men's sports, and the model that we think fits within the missions of our institutions.
Just also to add on to that, though, we shouldn't discount the reason why there is a settlement in this case, right? The reason you started this morning by saying as of this date and this time, because the lawsuits are coming fast and furious, and there has been, I think, very thoughtful attempt to try and resolve lawsuits to stem that while people figure out what is the correct model for college sports as well.
So Janet, I have a question for you. First, thanks for everything you've done in the Title IX arena. Many of us have benefited from that. On the topic of significant assistance, you mentioned that the Office of Civil Rights stated that Title IX prohibits schools from providing significant assistance to any outside organization that discriminates on the basis of sex. Can you elaborate a little bit on what that may mean for schools and the collectives that support their programs?
So now we're going to take this in a whole different direction. It's great to see you, Christine. And it's great to see, I am so appreciative of faculty, athletic representatives, and all that they bring in college sports. And you've always been a wonderful colleague in that respect. As I said in my remarks, right, the market does play out and is able to play out in third-party agreements. So collectives we've seen also NIL agreements that are coming directly from the companies that are not going through collectives either. I think what the Office for Civil Rights is basically saying is you cannot sort of partner with a third party to do what you're not permitted to do under law. And we've seen some of this come out in a number of OCR complaints that were filed in recent years against schools that were advertising just broad-based scholarships to attend school that were limited to women in STEM, for example, or other categories that on their face were thought to be discriminatory. And so schools were told that they needed to disassociate, right? They needed to take down links to those particular organizations unless they could show that they had a very specific framework for applying financial aid broadly across campus, right? That took into account and offset some of those scholarship provisions. In the collective arena, schools are in an interesting position. Collectives are very, very invested in trying to help their particular school programs, and they want to be partnered quite closely with the schools in doing so. And they want to be able to say to their members that they have the endorsement and the support of the athletics programs. Now, the NCAA has taken significant steps to allow schools to work with collectives and other third parties, facilitate deals, additional things that create risk for individual institutions. Now, the collectives themselves are typically not subject to Title IX, right? Unless it would have to be a whole lot of different facts involved. The liability runs to the schools, not to the collectives. So schools have to evaluate their risk profile when they, for example, have collectives who state quite clearly that they are set up to support men's basketball only or support football only, or where they may be stated on that they're supporting all sports equitably, but where the efforts, the outreach may not be supporting that. So we have not seen a lot of movement from the Office for Civil Rights in this respect. We will see how one court case that has been filed against one of the NCAA Division I schools that has an NIL element to it may play out. But the significant assistance doctrine is well established and would apply in this context.
Our conclusion time at 10:30 is fast approaching, so we may have time for one, maybe two more questions. I think, Peter, you're next.
Thank you. Jill, when it comes to the employment of college athletes, do you think there's a difference between the athletes in specific sports or groups of athletes, say in Power Four versus those outside of Power Four? And if there is, how should schools outside of Power Four go about emphasizing the differences?
Thanks, Peter. Great to see you. As I sort of mentioned earlier in response to President Barron's question, I think, if you let this play out naturally, it's a fact-intensive exercise, and I think those facts can differ. So I'll leave it at that. Short of a public policy that they should all be employees or none of them should be employees, I believe it's fact-intensive, and I do believe that facts differ. So we'll start there. What can non-Power Four schools do? Sort of references very vaguely at the end, but I think one thing we're doing is we identified the 9 reasons that St. Joe's sponsors Division I athletics, and we're testing our assumptions. Things have changed so significantly over the past 2 years, 5 years, 10 years, that reasons you used to have may not hold true anymore, right? Enrollment trends have changed, discount rates have changed enormously. And so much more about your athletic programs. And so I think, I don't know that we'll get a chance to stand up in front of a court. I don't know that all the amended complaint will have St. Joe's involved in discovery, but I think it's a great exercise for non-Power Four presidents, athletic directors, boards to sort of review and evaluate why they're sponsoring Division I athletics and test some assumptions on whether those still hold true. I think I've learned a lot about our athletic department. I've also spent enormous amount of time talking to our student athletes about the issues and seeing where they feel and what do they feel like they're playing or do they feel like they're working. So those are some thoughts on what people can actually do to start digging into the facts.
Great. Gabe, you mentioned that things are changing sort of almost minute by minute with the House settlement. What I was wondering is if the settlement doesn't move forward, what's your estimate in terms of how quickly this could get through the normal court processes, including all the appeals?
I would not use the word quickly to describe the timeline. It's a great question. The trial date had been set for early next year. Now that we don't know when, if the settlement talks fall through, when the new trial date will be set. But just looking at the 2 prior antitrust cases involving the NCAA and their timeline, the O'Bannon case was filed in 2009, and that ended in 2015. And that was just through the Ninth Circuit. That didn't go all the way up to the Supreme Court. The Alston case started in 2014 and was decided by the Supreme Court in 2021. So these are slow moving processes. And that's just if everything continues to go as went in these previous cases. Obviously, there can be quicker resolutions of these cases. There can be a settlement at any point along that way, even if these settlement talks fall apart. And there can be faster resolutions of these cases without full trials. But it will be a very long process. And it will be between the NLRB and the federal courts, it's a little bit of the tortoise and the tortoise. This is not much of a race. So for, again, relying on the courts to determine the future of college sports, it's unpredictable and it's slow.
All right. Thank you all again for, obviously the questions and certainly the important answers. We are at that time, approximately 10:30, which is the conclusion of this first session. We're going to take a 15-minute break, and afterwards we'll begin our second session. But once again, thanks to the panel, and thank you for the questions.